Okay, good morning, everybody. We're going to go ahead and get started. It's 11:33, and we may have a couple more people join us, but want to thank Marc, Freedman, and Roger. I don't want to mispronounce your last name.
Gibboni.
Jaboni, okay, for joining us today, and they're going to be giving us an update. Marc is the Vice President of Workplace Policy, the Employment Policy Division with the U.S. Chamber, and Roger is the Senior Director, the Institute for Legal Reform with the U.S. Chamber. And then later we'll be joined by Tom Sullivan, Vice President of Small Business Policy with the U.S. Chamber. And I want to thank y'all for joining us today. We appreciate you taking time out to share with us critical and important information. And thank everybody for joining. And with that, I will turn it over. And I think Laura's going to be running the slide deck for you.
Roger and I decided he should go first, and then I'll come in behind him. So
yeah, and I'm just going to start off without any slide deck, so I'll just kind of jump right into it. And first of all, thank you so much for inviting us to participate in this webinar today. It's always a great opportunity and a great pleasure to touch base with our local and state partners on various advocacy issues, but that's now especially the case in the context of the many policy discussions around COVID-19 response and the various relief efforts related to it. It's also helpful for us to get a sense of what you're hearing and what you're seeing, because I think Marc and my other chamber colleagues will agree with me when I say that really does inform a lot of what we do here at the chamber and here in Washington. And again, that's certainly the case in the context of the liability protections related to COVID-19 that I'm going to talk a little bit about today. Thank you for introducing me, Mike. As you mentioned, my name is Roger Jaboni. I'm a Senior Director of Legal Affairs here at the Chamber's Institute for Legal Reform, or ILR as we call it. ILR's mission, as stated, is to champion a fair legal system that promotes economic growth and opportunity. Basically, what that means to me is that we work every day at the state and federal levels to ensure that businesses of all sizes, large and small, can do what businesses do best: innovate, employ, and serve their communities without constantly being in fear of being subject to frivolous lawsuits. So if it's okay with you guys, my plan is just to talk a little today about what we're seeing at the federal level in terms of liability protections that have been proposed in response to what really is a coming wave of COVID-19 related lawsuits. And then I'll shift over to talk a little bit about what's happening at the state level in terms of both legislation and executive orders. And there's been a ton of activity at the state level, so I think it'll be a really good conversation. After that, as I mentioned, I'd really just love to open it up to you all and hear what you're working on, what you're seeing, and any questions you might have, because that's really what we're here to do today, is have a dialogue with you all. I'll start by saying that these liability protections we're going to talk about are incredibly important, not just to businesses, but also to educational institutions, nonprofit organizations, local governments, hospitals, doctors, nurses, frontline responders. And we've heard from many of our state and local chambers that this issue is a top priority for their members coming out of the pandemic. And I think the reason for that is that, businesses and all these other entities need some confidence and clarity when they want to reopen their doors in a safe and sustainable manner. And liability protections are definitely part of that equation. So let's just jump right into kind of the federal level. I'll start by was I muted there? Sorry about that. How long have I been muted?
So it muted you for just a couple of seconds, maybe 10 seconds.
All right, so I'll start at the top just to go back to kind of what's happening at the federal level. I'm going to start by going through the kind of core provisions of the Safe to Work Act, which is the federal legislation that was introduced in late July by Senate Majority Leader Mitch McConnell and Senator John Cornyn of Texas, of course. And this is the legislation that could ultimately be included in a next round of COVID relief legislation, or a phase 4 round of COVID relief legislation. And then I'll talk a little bit about kind of what the state of play is in terms of getting those liability protections into a larger COVID-19 relief package and getting that relief package across the finish line. I don't think I'm going to be telling anyone anything they don't already know when I say that negotiations and conversations around a larger COVID relief package have been at an impasse here in Washington for the last few weeks. So we'll talk a little bit about what the outlook of that looks like. So there are 4 core reform principles or pillars of the Safe to Work Act: exposure liability, medical liability, product liability, and labor and employment liability. Let's start with the first one, exposure liability, or as a lot of folks are referring to it, business exposure liability. This is the set of protections in the Safe to Work Act that's going to apply not only to businesses, but to, as I mentioned earlier, educational institutions, nonprofit organizations, local governments, and a whole host of other institutions and entities. This part of the Safe to Work Act proposes various liability and procedural protections, but I'm going to highlight just two of them. The creation of a liability safe harbor and the creation of a federal cause of action. The liability safe harbor ensures that if a business or other entity is doing its best to operate in accordance with the applicable government health guidelines, so local government health guidelines, state guidelines, federal guidelines related to COVID-19 health practices, they're not going to be subject to an ordinary negligence standard in a civil lawsuit related to COVID-19. Now, I'll be sure to say that that doesn't mean that there's some blanket immunity or free pass for any institution that acts in any way. In fact, the Safe to Work Act very explicitly says that if an institution operates with gross negligence or willful misconduct, they're not going to be able to avail themselves to this liability safe harbor. And that's a really important part of this proposed legislation and something that we were really happy to see that the drafters included in it. I also mentioned that this would create a federal cause of action. Basically what that means is that regardless of where a civil COVID-19 related lawsuit is brought, whether it's in federal court or state court, these suits, if they fall under the umbrella of the Safe to Work Act, are going to find their way into federal court. That's important because, we talked about clarity and certainty in reopening at the top of the discussion. And, a big part of that is having some kind of predictability in terms of what liability means. And if different state courts are interpreting liability in vastly different ways, that's going to become a very difficult thing for businesses and other institutions to navigate. And, businesses today, large and small, from mom and pop shops to the biggest businesses, are operating across state borders. So in order to have that kind of predictability, a federal cause of action that establishes a uniform body of law around liability is really important. Moving on to the second core pillar, medical liability. The liability protections here are extremely similar to those that are proposed in the exposure liability context. So it's a liability safe harbor, an exception against that safe harbor for gross negligence and willful misconduct, and a federal cause of action. This time, though, it's going to apply to doctors, to nurses, to other frontline medical responders, and the institutions or the facilities where COVID-19 patients are being treated, like hospitals. This is really important because those folks, just like the businesses we talked about earlier, really need that clarity and confidence that they're not going to be sued at the back end in order to go and put themselves on the front lines and continue to do the work that we really, really need them to do. Product liability. The Safe to Work Act makes some additional protections under the PrEP Act, and I'll tell you about the PrEP Act here in a second, for personal protective equipment and the distribution of personal protective equipment. There's been a lot of discussions in response to COVID-19 about personal protective equipment. The PrEP Act is a piece of legislation that was passed through Congress about 15 years ago, and it provides some limited liability protections for medicines, vaccines, medical devices, and some personal protective equipment in the cases of emergencies. Well, what the Safe to Work Act would do would be to expand that universe just a little bit to provide liability protections for some PPE that is being used in response to COVID-19 that otherwise wouldn't have gotten kind of pulled into the PrEP Act liability coverage before. Lastly, I'll talk real quickly about labor and employment protections. We have Marc Freedman here, who's an expert on labor and employment issues, so I'll just kind of go over this quickly. The section of the Safe to Work Act that speaks to labor and employment protections would provide protections against liability and government enforcement actions under certain labor laws if an employer makes an effort to comply with coronavirus-related public health guidance and regulations. It also does some other really important and interesting things, like provide liability protection for workplace COVID-19 testing. So this would ensure that employers will not be liable for certain actions or injuries resulting from workplace COVID-19 testing. So where does this all stand? Our understanding, based on numerous public statements and reports, is that liability protections remain a top priority and really a red line for Senate Majority Leader Mitch McConnell in any next round of COVID-19 related relief. To that end, about a week ago, I want to say, Senate Republicans introduced a skinny or a pared down version of their larger COVID-19 relief package that they had introduced a few weeks ago. And they're now calling that the Delivering Immediate Relief Act. We were really, really happy to see that in the Delivering Immediate Relief Act, the provisions of the Safe to Work Act, the liability protections set forth in the Safe to Work Act were almost identical in this new skinny down COVID package. So that was an indication to us that this remains a top priority for Senate Republicans and a lot of other folks on the Hill who are continuing to work through negotiations. As you probably know, and as I mentioned before, the negotiations on a larger relief package have been at an impasse for the last few weeks. That's for various reasons. Reports say that that's primarily around costs of another relief package, not really having to do with the liability protections. It's hard to say what comes next, as this is really kind of a day-to-day thing. But there has been some discussion around including COVID-19 relief in a spending bill, meaning that would have to happen in the next couple of weeks by the end of September. Some reports have talked about that happening, but we'll see what happens. Right now, there's still a lot of question marks, but what we really hope is that folks will continue to reach out to their senators and their lawmakers and encourage them to include the provisions, the liability protections in the Safe to Work Act in any next round of COVID relief funding. And that's really important because these lawmakers need to hear from their constituencies and the businesses in their communities, telling them how important these liability protections are in order to get their doors open and their local economies back on their feet. So let me now shift over to what's happening in the states. As I said at the outset, there's been a ton of activity, and the proposed protections are really wide-ranging. Everything from liability protections for healthcare workers to some states passing liability protection packages that apply to healthcare workers, personal protective equipment, business exposure, et cetera. As of yesterday, 30 states have taken some action to implement liability protections related to COVID-19. I'm just going to break that down a little bit further. 13 states have provided protections for COVID-19 related exposure, 2 of them through executive orders and 11 through legislation. And when I say COVID-19 related exposure, this is, again, the business exposure liability, educational institutions, nonprofits, kind of that bigger bucket of liability protections. 12 states have provided liability protections related to personal protective equipment or products that are being used in response to COVID-19, 1 through an executive order and 11 through legislation. All 30 of those states have provided liability protections for medical and healthcare responders who provide COVID-19 related care, 15 of them through executive orders, 6 through legislation, and actually 9 states have done both. The governor has passed an executive order, and then the state legislature has followed up with a piece of legislation implementing liability protections. Just as a side note, as I know it probably would be of interest to you, as of now, Texas has not implemented any COVID-19 related liability protections via legislation or executive order. So in sum, and I'm going to kick it over to Marc here, there's a ton of activity both at the state and federal level. The states are getting a lot of really great things done in terms of providing, healthcare workers with liability protections, businesses with liability protections, doing some really important work to ensure that businesses and healthcare providers can do their jobs. But we remain, resolute in our belief that a federal baseline is still really necessary in order to ensure that everyone has that confidence and clarity in order to open and restart in a safe and sustainable way. As I said before, a liability patchwork across the country simply isn't sustainable. And the only thing that we believe that can solve that is a federal liability protection baseline that states can then build upon. And we're really hopeful that the provisions of the Safe to Work Act will make it into a next round of COVID relief funding. And I'd be happy to answer any questions you have, both at the federal level or the state level. And I really look forward to having a little bit more of a conversation with you about this. So thank you.
Okay, thank you, Roger. Laura, are you able to get the slides up and we can walk through that? Or Michael? I'm not sure who's handling that. In the meantime, let me just sort of kick it off here. Here we go. So I have a couple slides here that just sort of help give you all something to look at while I'm yammering away, and hopefully give you an opportunity to capture some information after we finish our conversation. Okay, can we advance the next slide? Can we put the next slide up, please? Well, I'm going to jump around through a couple different issues here, including what's going on in the paid leave debate that came out of the COVID legislation, and then a little bit of unemployment insurance. Excuse me. I want to touch on the liability discussion just for a brief point to highlight something that Roger didn't get a chance to get into. And then we'll finish off with something that may be coming up in the next Congress, depending upon the results of the election. So if we can get to the first slide, in the paid leave, oh, well, not quite. This is why I wanted somebody else to handle this, because I didn't want to take care of it. So I think we all know that coming out of the early relief packages, the Families First Coronavirus Relief Act, which was the first relief package, it included a federal paid leave benefit on both sick leave and family leave.
So the city was going to be able to accommodate the light duty, but now they can't accommodate the light duty, so we have a light duty guy.
Hello?
For at least a week. His follow-up is on, well, not quite a week. His follow-up is on Wednesday.
I think somebody should mute. There we go. That would look like we're making progress.
Do we have him come to the office? Here's the problem. Toby needs that front office for skilled trades training next week.
Okay.
I got Carol in here.
So here's our paid leave discussion.
We don't have enough stuff to give her or to manage it.
Can somebody?
I don't. We're gonna be out.
Okay. Sounds like somebody needs to use their mute button, please.
Let's just have them come in. We may send them home.
So, anyways, here's the sick leave and paid leave discussion. Of note, there's a 500 employee threshold. Employers below 500 employees are covered. That is, in fact, the SBA size standard for small businesses in most cases. And the reason that was chosen is because the feeling was that businesses below 500 were least likely to be providing this paid leave benefit. The chamber supported this idea on the notion that in order to get employees out of the workplace that were sick, we needed to have a paid leave available for them to get out of the workplace. So it was I think a good deal. The important thing is that it's temporary. It ends at the end of this year, and also that it's backed up by tax credits. If we can get to the next slide, we'll see that discussion a little bit. Thank you. So there's a reimbursable tax credit involved here, which means that the amount of money that employers have to put up for their cost of leave up to a certain amount can be taken off of your tax liabilities. One thing of note is that the Democrats in their next package of relief, the HEROES Act, have expanded this into next year, and they've also taken away the 500 employee threshold. So they'd like to really go a lot further with this than is currently in law. I've included a link down there to the Department of Labor's website that has a ton of really helpful FAQs on this question, as well as other COVID-related questions. I would definitely recommend that anybody who's trying to figure out what to do here, check that page out, because there's a pretty good chance that they've hit your question. We did submit some questions to them. They did a great job of soliciting questions, and they keep updating it regularly. So keep your eye on that. If you don't see an answer to what you're looking for, keep checking back. It may just actually show up at some point. If we can get to the next slide, the unemployment insurance stuff is the other area that got a lot of attention in the legislation. One of the interesting things is that this made UI available for self-employed workers as well as independent contractors for the first time. Typically, those folks are not part of unemployment insurance benefits. There were a couple other additions. They expanded the amount of leave, or they expanded the time that leave was available. I'm sorry, not leave, unemployment insurance. And then the big discussion has been on this final point about this added $600 per week benefit. That expired on July 31st. But what we were hearing from a lot of companies and different sources was that employees who were offered work were declining it because they thought they were doing better on unemployment and didn't want to come back to the workplace. So it was distorting the labor market. There seems to be a fairly broad consensus that there needs to be an extra benefit offered, but $600 is proven to be the wrong number. So we're not sure where it's going to settle out. Right now, we're working under the executive order that President Trump signed that creates this lost wages assistance program. The key thing there is that the federal benefit now will be $300 more. It's supposed to go to the end of the year, but the amount of money they have to spend here may only last about 5 or 6 weeks. The other part of that was states were going to be required to add $100 per week, but they are now allowed to take credit for what they're already paying. So in reality, they don't actually have to add an extra $100. One of the big problems with this is that the states are having a hard time implementing the new payment process for this extra money. Their systems just aren't geared up for that, and they're having to do a lot of retrofitting, which means that there's a real scattered uptake among the states in terms of who's actually offering this benefit. We do think it's going to get up there, but it's not online yet in all the different states. Okay, so next slide, please. So back to the liability reform discussion, and the only thing I want to point out here, additional information, is that the legislation includes a provision for specificity of pleadings. What that means is that for anybody to bring a lawsuit, they have to demonstrate that the exposure in question, whether they're an employee or a customer, actually happened at that place of business. So they actually have to demonstrate that they were exposed at that place of business, which is a key point. If you're going to bring a lawsuit, you want to make sure that the person you're bringing it against is really the key person. So that specificity of pleadings issue is a really valuable part of that legislation, and I hope that that's something that stays in there. Next slide, please. So we know that a lot of employers are working on bringing their employees back, and we thought it'd be helpful to line out some of the questions we think you should be working through. I'm sorry, we don't have the answers here. We just want to make sure that the right questions are in front of you. I'll draw your attention to that second bullet down there on the use of PPE. This is, of course, personal protective equipment, and it's, for the most part, we're talking about face masks and maybe face shields and probably some gloves. This flows out of what's called the OSHA hierarchy of controls, which is a way of talking about the different levels of controls that employers can go through to protect against the hazard. And in fact, PPE is regarded as the least effective control, but it's the one you default to when the other controls don't work. So the other controls are things like engineering controls, where an employee doesn't have to do anything to have the protection in place. And the classic example of that right now are the plexiglass shields that you see at a lot of retail counters at the checkout, where there's a shield between you and the checkout person. That protects the employee without them having to do anything. That's an engineering control. So, you work through these different controls, and then if you can't provide some other level of control, you use PPE, which is the masks and gloves and face shields. I want to divert for just a moment on this question of the OSHA requirements, because there's been some conversation around that. In particular, the Democrats want OSHA to issue a new regulation that would convert a lot of the recommendations into mandatory requirements. Right now, employers are obligated to protect their employees. How they protect their employees is still something they can decide on their own. If the OSHA rule is issued, if the OSHA is required to issue a rule, it will mean that the current suggestions on how to control employees, how to control exposure will become mandatory, and employers would be subject to citations on how they protect employees, not just whether they protect their employees. So you may hear that being discussed. The Democrats have been making a lot of noise about that being part of their package and a requirement for any kind of final package. Next slide, please. And this will be the last one. So this is the big union labor reform cornucopia package. And it's got a lot of stuff in it that some people may remember from previous efforts, and then it's got a lot of new stuff in it that wasn't there before. Joe Biden has in fact supported this legislation. If we get a Democrat majority in the Senate and they do away with the filibuster, this becomes a live fire exercise. So just to let you know, something that's out there that could become a big problem in the next Congress. In addition to all the provisions that help unions organize, I think the thing that's going to really scare people is this provision about imposing the California independent contractor law known as AB 5 across the country. And in California, when they passed it, they actually included a lot of exceptions to industries that wouldn't be covered. The federal legislation version of it does not include those exceptions, so it's even more onerous. And it really would make maintaining independent contractors extraordinarily difficult. It's targeted at all the gig economy folks, the Ubers and the Lyfts and stuff like that, but its impact would be far and wide. And we think that alone is the reason why this bill is a bad bill. Then, of course, we have the joint employer question involved there, and it would do away with right to work laws, on and on and on. There's lots of stuff to talk about this, but I just want to give people a flavor for what that's about and why we think it would be a very bad piece of legislation to move. With that, I'm out of slides, and I'm happy to take some questions. I'll stick around on the call for a little while longer. Thank you. Thank you for the help on the slides, Laura.
No problem, Roger.
Looks like Tom is on.
Is Tom on? No. Does anybody have any questions for Roger or Mark?
Well, Roger too.
Yeah, I'll just say, Mark, that's a great point about the specificity and pleading standards. It's an important point and something that I too hope makes it through into the, a final package.
Say what? Tom, are you ready to start your presentation? Do you need me to do the slide deck, or are you going to do it?
I got it. Thank you.
All right. Thank you very much.
Oh, I need to be undisabled.
Michael's making you a co-host right now as he's running to his office.
Thank you, Michael.
There you go, Tom. Sorry about that.
No worries. Hi, Michael. Thank you. Let's see. Here we go. All right. Well, thank you. It's great to be here. I've told many of my colleagues that a blessing from COVID, at least from where I sit, is I've been able to visit with more chambers in the last 6 months than I have in the last 6 years. Yesterday, I was at the Grand Canyon. This morning, I was down in southern Georgia, and now I get to go just outside of Dallas. So it's great to be with you this afternoon. I truly only wish that it was there in person. My basement where I'm working in Alexandria, Virginia, is not as nice as the offices that my colleagues have. And so I'm using as the backdrop our headquarters building that is adorned with the jobs campaign from a few years ago. So what I'd like to do, Laura, is just start off real briefly looking backwards a little bit. If we look back 6 months, and I think most of us think that 6 months ago was 6 years ago, but it really was only 6 months ago when it was very clear that the coronavirus would extract an awful economic toll on our country. Congress came together in remarkable bipartisan fashion to pass 4 laws to help small business. Don't worry, I'm not going to go into detail in all of those 4 laws. The only reason I say this to start my presentation, and there are only 3 slides, is just to give some optimism that we are going to get a stimulus package done. It is incredibly frustrating that we're not there yet, but it might help from a perspective of been remarkable with the president and Congress working together to get federal aid to small businesses. That's not, it obviously has not been enough. No one anticipated the coronavirus having the type of impact that it is currently having now. So we're pushing aggressively for additional help. And Marc and Roger have already spoken about these things. I'll get into a little bit more detail from a small business perspective in this presentation. Again, kind of setting the stage from a little bit of a step back component. PPP, which is the acronym no one can say without spitting on their smartphone or computer screens in virtual meetings. It is truly amazing to think about the volume of loans that have come out from SBA in the last 4 months, 4 or 5 months. And when you look at the numbers that are on this slide, 5,212,128 loans, keep in mind, these are more loans in 4 months than the SBA has issued in totality in its 65-year history. Also, I do want to point out that some heroes that aren't mentioned in day-to-day, certainly not mentioned in fake news, are the bankers and the lenders. It is no coincidence that these community banks and local representatives from national banks are leaders in every chamber of commerce across the country. And the reason why I'm narrowing in on this is that only 1,200 banks offered SBA loans pre-pandemic. Now we have close to 5,500 banks that are offering PPP loans, other SBA products to help small businesses get through the pandemic. And that's pretty remarkable. And the bankers and lenders deserve a lot of credit. In the middle of those first couple of rounds of PPP loans, remember being on virtual calls like we're on right now, and small business owners desperate to get a PPP loan. And lo and behold, a lender would also be on the line and say, hey, George, call me after this meeting. And that's what local chambers are all about. That's what networking and chambers across the country are all about. Certainly has provided an enormous benefit through the pandemic. Now, as far as statistics go, we have a partnership with MetLife where we take the pulse of small business, usually every quarter, but we've done it every month during the pandemic. And this is where I get to pretend to be an economist. I get to say on the one hand, but on the other hand. Now, on the one hand, in a very positive way, our last MetLife coronavirus poll showed that small businesses are really bullish on 2021. And when you look at the level of optimism for small business, it is at about a 53% level when looking at 2021. And the important thing is that that's compared to a 50% optimism of 2021 investment when those same small business owners were asked back in May. So we do see a slight uptick in the optimism to 2021. And that actually, the reason for that is fairly obvious. More and more small businesses are reopening getting customers more comfortable coming back into their shops, their restaurants, and other establishments. More customers obviously means more revenue that leads to greater optimism. Now, on the other hand, there is some bad news that certainly has showed up in our polls. And that is when you look at small businesses' view of overall health, how am I doing right now? That level is at about a 55% level. Seems okay. The problem is that it is 14 points lower than at the same time last year. And that is a significant hit towards small businesses' confidence in how they are doing at a particular moment in time. Now, I have on this slide mention of really one of the most eye-popping statistics. It's horrible, but you deserve to know what we're finding. And that is that the hardest hit small businesses from a demographic, a social demographic perspective, are Black-owned small businesses, minority-owned small businesses. What our data show is that 66% of minority-owned small businesses believe they're going to have to permanently close, which is horrible. And it also explains why we're leaning in so aggressively to try to get Congress and the White House to come together and negotiate for another stimulus package. So how are we doing that? Well, really, we're doing everything we can, and we certainly lobby with your help and the help of about 1,600 to 2,000 of your closest other chamber friends from across the United States. We try to very simply put what Congress has to do. And we like to, if it rhymes, that's even better. It means more and more members of Congress will remember it. So we like to say it's as easy as 1, 2, 3. And Laura, there you have it. I've now put a song in everybody's head. Jackson 5, ABC. My teenage boys tell me that that's an earworm. An earworm is a song that you just can't now get out of your head. So you're welcome. The hitch, though, is there's actually 4 points, but 4 doesn't rhyme with anything. It's not in any song, so it's as easy as 1, 2, 3. 1, increase financial assistance, pretty self-explanatory. 2, expand the access to PPP and other SBA loans to our local and state chambers of commerce friends, otherwise known as 501c6 nonprofits that have been shut out of the PPP process, which is insanity. In my view, that's like telling an emergency room doctor that, hey, thanks for all your help during the pandemic, but guess what? You don't have access to our healthcare system. It just doesn't make sense. And what makes this so frustrating is that on hundreds of virtual webinars like we're having right now, we ask members of Congress whether they would support this, and everybody's head nods. It's like a line of bobblehead dolls. But then when it comes to legislative action, nothing's been done. Now, right now, it looks as though in what Congress is considering, local and state chambers of commerce who have 150 or below employees will be able to access PPP, which is good, but it keeps coming. It's a weird way to make a sausage because that ingredient keeps coming in and out of that sausage every time we speak with folks. So the extent that you're talking with your members of Congress and they're asking what they can do to be helpful, please explain that local chambers of commerce should have access to this federal lending assistance. And third, simplification. This is a classic case of part of government is trying to help and the other part of government is not being helpful. And we'd just like for that to be simplified. I'll give an example, Laura. We know that if you spend the PPP loan the way that SBA has told you to, it's forgivable. And then along comes IRS and says, hey, that's wonderful that we've forgiven these costs, but guess what? When you can't take a business deduction for any of those things you ordinarily would have taken a business deduction on that are already forgiven under the PPP program. That is crazy. If if Congress wants to free up cash for small business, just free up the cash. Don't have one part of government saying we're freeing it up and the other part saying, oh, well, you're going to pay for it in taxes. Just doesn't make sense. Senator Cornyn, one of your senators from Texas, has come up with a fix for this. And we are pushing for Chairman Rubio of the Small Business Committee to include your senator's proposal to correct really this idiotic one part of government, IRS, saying we're taking some money away. And at the same time, the other part of government, SBA, saying we want to free up that money. So thank you to Senator Cornyn, and it's up to all of us to try to convince that for being part of the package. So easy as 1, 2, 3, but what's the fourth? Well, the fourth is what Roger described earlier, and that is liability protections. We have polling data that show that 80% of small businesses believe that if they're taking the steps to protect their employees and protect their customers and simply following the advice of local health officials and the CDC, they should not be victimized by profiteering plaintiff attorneys. So I won't go on longer than that. I know Roger has already covered that in more detail, but that is a fourth thing that we are pushing for, and we're optimistic. And I should say, since I am talking to wonderful folks from Texas, and I say that because I married a Texan, I actually am pretty optimistic about the liability protections. Here's why. Because a Texas pro-business Democrat in the House actually was the first member of Congress to even introduce liability protection. It was exclusive to small business. We think that it should be bigger, but it was Henry Cuellar from, south of where you all are, but Henry Cuellar is one who introduced bipartisan legislation that meets what the U.S. Chamber really wants, although we want it expanded to all businesses because that simply makes common sense. Last but not least, the resources that we provide are intended to help small businesses. And these resources, how-to tips, translation of extremely complicated government information into tools and tips that even I understand, are translated into English and Spanish. We want small businesses to access this information, and we truly have heard that this is an R&D effort by our friends in the local chambers like you. The R&D is rip off and duplicate. And in this case, plagiarism is the most sincere form of flattery, because we can produce all the information in the world. If no one's using it, it's not going to do any good. All of this information is available on our small business digital platform, uschamber.com/CO. I will get into a little bit of particulars about what the stimulus looks like and what we are pushing for as far as small business goes. We are pushing for them to reopen PPP because, in fact, there's over $130 billion left. We know that minority businesses and sole proprietors needed more time to access PPP. We also believe that there should be, that small businesses should have targeted second PPP loans. And we've been working with Chairman Rubio and the Senate Small Business Committee, and they have said that if you have 35% of your receipts from last year, if that's where kind of your business operations are, you would qualify for a second PPP loan. Also, we have in the legislation that's been drafted and is kind of moving along a little slower than we would like, do have a simplification component to PPP forgiveness. We are saying, look, every small business that took a PPP loan signed on the dotted line that says, I will spend this the way SBA told me to. That is enough for the feds to go after the bad guys. The feds can already go after the people that spent the money in Las Vegas. They can already go after the folks who bought Lamborghinis with the PPP loans. So we shouldn't have to worry. We shouldn't have to burden small businesses, especially those that had PPP loans under $150,000, we shouldn't be burdening them with red tape simply to prove what they've already said they've done. Let them get on with their businesses, reopen their businesses, contribute to the economy, contribute to getting Main Street communities back on track rather than filling out paperwork and having to deal with red tape. This is legislation, bipartisan legislation that's been moving in the House and the Senate. It is included in both versions of what we've seen in the Senate, and we're optimistic that it'll be part of a stimulus package. Although we continue to be very frustrated that there has been no productive conversations. I'm careful to say that because Speaker Pelosi did speak with the White House Chief of Staff yesterday, Mark Meadows. Unfortunately, it just doesn't seem as though it produced much movement. A little bit of a hint for insider baseball perspective. As soon as you see Speaker Pelosi meeting with Secretary Mnuchin of the Treasury, that's an indication that talks and negotiations are back on track. And we're doing everything possible with your help to make that happen. Laura, with that, I'll shut up, take any questions that you might have or observations or, quite frankly, corrections, because many of times you guys know what's going on down there in Main Street before we do here in the Washington, D.C. area.
Okay, thank you, Tom. Does anybody have any questions for Mark, Tom, or Roger?
Laura, I do see that there's an observation from Lexi. So Lexi, thank you for pointing this out. There are lots of information in the poll. One observation that Lexi picked up on was that businesses felt that local competition had increased. And it's actually one of the fascinating things about polling small businesses. There's always two sides to every coin. You know, on the one hand, you don't want more competition, but on the other hand, you do want more businesses reopening. And of course, with those businesses reopening, there is kind of greater competition amongst businesses in a particular area.
Also, Tom, Genevieve has a question for Mark. She would like to know where she can find information for the California independent contractor. That information, where can that be located?
Let me just put myself up there. Yeah. Quite frankly, it's out there in a lot of different places. The bill is let me give you a little history here. There was a court case called Dynamics where the California Supreme Court adopted what's called the ABC test. ABC, not to pick up on Tom's little Jackson 5 reference, but this is just how the test is known. There's three provisions that are known as A, B, and C. And in a nutshell, what it says is that unless a person, a worker, can demonstrate that they are not doing the same work as the company that hired them, and they have an independent operation, they have to be considered an employee. And that's basically how the ABC test works. It very much favors finding a employment relationship rather than independent contract relationship. So that was a case out of the California Supreme Court. There really wasn't any way to challenge it. And then the California legislature took that case and codified it in legislation that became known as AB5. And AB5, as I said, actually has that same test in it, but also includes a lot of different exemptions of industries that don't have to be covered. So if you were to Google AB5, you'd find that legislation out there. I'm quite confident we've got some stuff on hand that I can send back to you all, and you can circulate that, and you can start to get up to speed on it. It is, quite frankly, just creating havoc in California on the independent contractor question. And there are other states that are trying to mimic California now. You know, as California goes, so goes New York and Illinois. So some of those states are starting to try and figure out whether they can put in place their own versions of it. Ironically, the test that the California Supreme Court adopted, the ABC test, was originally in Massachusetts, but had some different provisions to it, so it wasn't so bad. The California version of it is much worse. and I will send some stuff back to you all so you can get up to speed on it. Sorry for the long answer.
Thank you, Mark. Anybody else have any questions?
I have a real quick question, and it's not directly related to any of your topics, but since the three of you have been out and visiting with other chambers and out in communities, and I haven't really heard any solid rumors or information about this, but have you heard anything or any, I guess, rumors or leads or ideas that there may be lawsuits stemming from any of the legislation or the shutdowns or making employees work from home or anything like that? Are there rumblings of any of that where an employee is going to sue an employer or an employer is going to sue the state or the federal government? Or have you heard anything along those lines?
Well, let me just take a stab at that because it is an interesting question and there's a lot of nuances that can flow from that. So one of the things that I cover is the wage and hour world. So the Fair Labor Standards Act and stuff like that, which brings into play the overtime question. And depending upon the nature of the work that your employees are doing from home and how they're classified as to whether they're exempt or non-exempt under overtime laws, you might have some issues with regard to the hours that they're working. And that's going to be dicey. I don't have a good answer for you other than you have to sort of figure out how to track your employees' hours or how to give them flexibility there. That's not an easy question, and there's pitfalls there that you could easily end up in. Same thing could happen in the context of OSHA, although my sense is the work that employees are doing from home is really not going to trigger the kind of OSHA safety issues that you normally have to worry about. So I think there are things out there that could happen. I've not yet heard of them coming up in that context, but that doesn't mean that they couldn't happen.
Yeah, I would just add to that, this isn't something specifically that ILR does a lot of work on, but you have seen some lawsuits challenging governor's executive orders, relating to, quarantine orders or mask mandates, school openings, things like that. So we've seen some of that. Where and when that kind of flows over into the liability and employment space, we'll see. I haven't seen a lot of it yet, but yeah.
Great. Thank you both.
Okay, anybody else have any questions?
And I just note that Tom very graciously and helpfully posted an article that we put up about the California independent contractor question. So I think that's probably as good a thing that we could give you as anything. So go to the chat room and click on that link and you'll be able to see what we've been saying about it. Thanks, Tom.
Yeah, and I'll just add, please feel free to reach out to me, and I suspect Tom or Mark as well if you have any further questions or want to talk through anything specifically. We're happy to be a resource.
Okay, thank you, Tom, Mark, and Roger for coming today, and thank you, Tom, for the song that now is going to stick in my head all weekend. All these resources will be on our coronavirus resource page on our chamber website. If you go there, click, you'll get the recording and the 2 slide decks from the gentleman. So with that, I want to thank you all for attending our Lunch and Learn today, and you all have a great weekend and have a great day.
Thank you all.
Bye.
So much.